Good morning, everybody. Kia ora, welcome to the second webinar. We're very excited today. I'm based in Auckland, and it's a great day in Auckland today. Not great, but it's okay. And my co-hosts this morning, William Hursthouse and Debbie Bryan-Lamb, we've just been getting ready to meet with all of you this morning, and we're so excited that so many of you can join today. So I'm going to make a concerted effort to keep the introductions as short as possible, because after speaking with William and Debbie, they've got so many fantastic ideas and thoughts and learnings to share with all of you. So the topic today is possibilities to commitment, creating robust and durable agreements. And in this discussion, we're going to focus on four main areas, and William and Debbie are going to be kind enough to share all their thoughts with us around those. So we'll be moving through the four topics. They are the do's and don'ts for agreement writing, exploring common pitfalls and how to avoid them, a little section on mediation and the law, and dealing with dilemmas, as well as a conversation around what to do when your parties just can't seem to come to an agreement, how to help them move forward from that. So those are some of the things we're going to be talking about today. We will have an opportunity for questions at the end, and you can add your questions through the chat function. Okay, so without further ado, I'm going to introduce our co-hosts, or my co-hosts, William and Debbie. William is a mediator based in Auckland. And William, would you like to say a few words?
Yeah, I'll say something. I promise it's less than a minute to hopefully lighten the tone to start with. I went to university in Auckland, and straight after that left and spent 3 years hitchhiking around the world to find the meaning of life. Came back here determined to build a meditation center. I did that, and after that people viewed me as a builder. So I was a builder for 20 or 30 years. Started having lawyers wanting me to be a construction expert, joined Amons, did the Massey course, did the leader course, and for the last 6 years I've been a family mediator with FairWay, and it just feels like the most comfortable or the best fit of all the things that I've done in my life. I really just love always having the children as the focus. It's just such a wonderful basis for having a mediation.
Yes. Thank you, William. And our second co-host is Debbie Bryan-Lamb. Debbie's based in Invercargill, so on the opposite side to William and I. And Debbie is an extremely experienced family lawyer and specializes in mediation work. Debbie, is there anything you'd like to say hello to everybody before we start?
Yes, kia ora everyone. I'm so thrilled to be here today. Just really briefly, I studied in Otago, and then I commenced practice in Chicago, and I've remained here where I've grown up, and I've been mediating for a number of years, and I'm very passionate about this role, and I think it's a real privilege to be able to service to the parties that we convene mediations for. So looking forward to today's webinar. Thank you, Samantha.
Thank you, Debbie. And in case I don't say it again at the end, because often we're running out of time, I just want to say thank you in the beginning to both of you for giving up your time and for being willing to come along and share what I know is going to be inspiring to everybody. I know that after speaking with both of you, I've already got a whole lot of list of things. I got the preview, sorry everybody, that I'm going to try in my mediation over the next few weeks. So I know that all of you are also going to be suitably impressed and thankful for the information that William and Debbie are going to be sharing with us today. All right. So enough about the blurbing. Let's go on to the real information today. The first thing that we spoke about when we were thinking about the webinar was the do's and don'ts for agreement writing. And while, I know that for myself, I've got a whole lot of little things in my head it's really nice to sort of encapsulate that learning. Debbie, would you like to start?
Yes, thank you, Samantha. Well, one of the do's and don'ts that I really place emphasis on when thinking about creating a robust and durable agreement starts right back at the beginning when I have that initial telephone discussion with parties and that preliminary meeting. And usually it's over the telephone, but I think it's really important if you're going to be able to persuade parties to remain in the same room for the purpose of the mediation, because not all couples want to stay in the same room even to negotiate a mediated agreement. It can be very, very worthwhile to try and have the parties buy in right from the preliminary discussion stage. So when I say buy in, I'm really excited about mediation, and I guess I show that in my enthusiasm when I first make introductions to the parties and say who I am, that I've been appointed by FairWay, and that I'm really excited about the opportunity to help them to work through the issues that have brought them to the mediation process, and that we're going to talk about what's going well, what's not going so well, and then explain to them that during the process there'll be an agreement that's going to be recorded as and when they reach conclusion on issues. So I think that it's really important and not to be bypassed the value of trying to forge a positive mindset and a relationship with the parties at that preliminary discussion stage. Because if you get them buying into the process, it's an alternative dispute resolution process rather than going down the litigation or the court or the lawyer path, then they too will look forward to coming along to the mediation and working so that they can to reach a better outcome than what they've got at the moment. So I think that it's really important that we don't bypass the importance of that preliminary meeting, because that's going to then pave the way for both of them collaboratively working towards the recording of an agreement that they're both invested in, because they're empowered to be looking forward to the mediation and to be contributing. Because if they can't do that and they can't negotiate something that's going to be better for the children and themselves, then the options are not through the mediation process. So I don't ever underestimate the value that I place on that initial contact and that time I spend, whether that's half an hour or 3/4 an hour or 15 minutes, with that's early stage of the mediation.
Thank you. Thanks, Debbie. Yes, I think that's so key is that the agreement is the product of a lot of thought and planning and processing and all of those things that you spoke about, which starts right at the beginning. It doesn't happen like magic. And what about for you, William?
Well, thinking about focusing on the part of the process where we are actually writing up the agreement, it didn't take me all that long to realize that it would be useful to have a whole bunch of questions and to be able to choose from that list in order to make sure that the people did cover off everything they needed to cover off in their written agreement. So I finished up, and I discovered in talking to Debbie yesterday that the same thing, she's done the same thing, that we finished up with a number of templates. And also, for those of you who are not lawyers, I'm guessing you already know that expression boilerplate, but there are a whole bunch of clauses that, in my case, have been collected from lawyers or else from previous mediated agreements, things that other parents have come up with, which I've kind of saved. And I have a series of open Word documents, templates, and those are filled with questions and with boilerplate clauses. And within those boilerplate clauses, there is always one or two bits that are highlighted, and those are the bits that we focus on at the agreement writing stage. So, for example, probably the most frequently used pretty standard boilerplate clause covers if one parent wants to take the child either out of the country or out of the city where it normally resides, then there's this very nicely written, lawyer-written clause, and the only thing that really needs to be discussed is the amount of notice that the parents agree on is required. So my default just starts at 4 to 6 weeks, and then they have a conversation about, how much notice is required. So yeah, the idea of having templates with questions and boilerplate clauses is really useful, I think, at the agreement. It expedites the agreement writing stage.
Good, yes, and I like the fact that you've got questions attached to them, William.
Well, the questions are based on this. Most of the parents, or many of the parents, have been through the parenting through separation course, and they provide a really good booklet which is filled with questions. So that became the basis of the first template I ever prepared. But since then, I've added a fair few things to it.
Thank you. Yeah. And Debbie, what else? What other top tips do you have for us?
Absolutely. I always think recording an agreement, it's really the devil's in the detail. And so there's no one size fits all. So whatever agreements reached between one set of parents is not going to fit necessarily the next set after that. So the devil's in the detail in terms of tailoring it for them and their family, and what's going to meet their children's best interests and needs. So in terms of the drafting of the agreement, it's really good to try and future-proof an agreement by having consideration as to timing. So don't have room for ambiguity. Don't have vagueness where you're saying that the children are going to be collected on Saturday, but leave out the time. Don't be vague like that, because Saturday will come, and if there's any room for creating conflict, it's not being specific, and it's not having the devil in the detail, as I call it, so that there's no stone left unturned, so that when they take away that signed agreement, they can go through they know what they've agreed to, and that they can recall the times and the dates, and it's all there in black and white. And also, when I say have future contingencies, if for some reason they can't collect, the children can't be collected by one of the parents, what might be their backstop position? Who might they rely on?
Yeah, so
to assist things like that. We got sound problems. That's it.
Thank you, Debbie. Thank you. If I could just check that everybody's still on mute, that's okay. I think there's a little bit of background noise coming through.
Sorry, Samantha, I've just unmuted.
Yes. No, you're muted now, Paul. You are muted now. Thank you. No, that's all good. Thank you. All right. Thank you, Debbie. That's really good. Can everybody hear properly? Can we all hear? I think so.
No, I can't.
No, Samantha, I can't hear Debbie.
Okay. All right. Debbie, can you go a little bit closer to your mic? Is that possible?
I'll see if I can turn it up a bit.
Or move closer to it?
Yes, I can do that.
Okay, hopefully that'll be a bit clearer. Can you hear me now, Debbie?
Yes, I can hear you.
Okay, all right. Yeah, that sounds a bit better.
I'll speak louder.
Great. Thank you. Problem solved. Okay. So, yeah, so I like that idea of the devil in the details, because, you know, we know that when things are going well, parties generally, you know, they'll be a little bit more flexible, or they'll work together. But when things aren't going well, they really need that default setting in a very specific agreement to help them through that time. So thank you. William, what about for you? What are your other top tips quickly?
Well, building on what Debbie was just saying about the devil in the detail, I've developed a few questions around making changes to whatever they've agreed. You know, the first hurdle is to get them to agree on some regular arrangement. And then before even looking at the special occasions, usually start thinking about, well, what about when you need to make some change to that regular agreement? And in particular, if they've got an older child, I tend to divide it up into parent-initiated changes and children-initiated changes, because when the child is really young, it's only ever the parents who initiated change. You know,
Yeah.
they can't come, they want to go away for the weekend or whatever. But once the child hits double digits, around 10 or 11, then I like to remind the children that they probably going to want to make changes of their own, and how the parents are going to deal with that, which can be very useful for them to suddenly be confronted with the fact that their child is becoming more autonomous and not entirely under their control anymore.
Yeah, and I like that, because often, if you know, it as you said, it creates the opportunity to communicate or have a conversation about what that will be like, and how they're going to work together around those sorts of ideas and have a plan in place. That's that's very interesting. I think that's a really good question. Thank you. All right. So
if I can just follow on from what William said too, Samantha, sometimes doing that can be a bone of contention as well, because one parent might have very entrenched views on, say for instance, take a mobile, what age should the child have a mobile phone? And those kind of occasions can cause conflict in itself, because one parent doesn't quite see that child is now reaching that autonomous stage, and seeing the child is not quite there, and one parent says, oh no, that they should be able to do this, or go here or go there. So that in itself can be quite a challenging discussion sometimes.
Yeah. But necessary.
Yes.
Yes. Really good. Okay. So those are some of the top do's and don'ts that William and Debbie use in their practice. And I think at the moment it would be useful for us to go on to the second part of our conversation today, which is around pitfalls. You know, getting ourselves into those difficult, sticky situations and then you suddenly sitting there going, I'm looking calm, but how am I going to get out of this? So I, for one, would really like to hear more about what some of those common pitfalls are for the two of you that you've identified in your practice, and how we can avoid them, because I think that's key. If we can avoid them, we don't have to sit there wondering how we're going to get out of them. So let's start with you, William.
Yeah, well, when I was asked to think about this, I didn't have any difficulty really, because for me personally, the biggest pitfall in the whole process is always taking responsibility. And I think that's because we all do this work because we want to help, and we all are hoping that these parents will come up with a really good outcome for their children. That's why we're doing this. So to kind of separate that out from, or to be able to cut off that feeling from taking responsibility for them actually producing that outcome, that's always a challenge. And I think the easiest way I found to overcome that challenge is to focus on the questions. I know that when I'm coaching at Amons or Resolution Institute, when I see lawyers in particular learning to be mediators, I see them constantly asking questions, and it's obvious that they want to understand, and that's why they're asking the questions. And what I see there is that the parties just start handing over, with every answer, they hand over more responsibility to the mediator. Every time the mediator wants information for him or herself, the parents assume this means they are going to take responsibility for sorting out this problem. So to avoid that pitfall, for me, the single best process is to be super conscious of why I'm asking the question. And if my focus is to help the parties understand each other, that's sweet. If my focus is, oh, I want to understand more, then I'm taking responsibility for solving the problem, and this is not going to end well. And once we get to the writing up the agreement stage, that's when it in particular can go wrong, because now they're constantly looking to me to tell them what should be in the agreement. Whereas if they've taken responsibility all the way along, it's much easier to get them to come up with their own words. So yeah, I think my top tip is to be super aware of why you're asking questions at all stages.
Okay. So by asking questions for your own understanding, I definitely resonates with me what you're saying. And so instead, where are you encouraging the parties to focus on?
Well, yeah, at the agreement
Yes,
stage in particular, the focus is all about how this might go wrong. Because if they're actually up to the agreement stage, they're usually feeling pretty pleased with themselves. Sometimes there's even euphoria. And so they're being really positive, and that means they just get sloppy and vague. And so our job is to say, oh yeah, no, that's great. So you're going to do this. And so then tell me more about that, or what's going to happen if that doesn't work, or, constantly trying to focus on what might go wrong for them, for those particular two people, what might go wrong for them, and what do they need to do to deal with that situation, to prevent it from happening, to recover when it does happen, all those sort of questions.
Okay, great, thank you. And Debbie, over to you.
Yes, I just want to pick up on a comment that William made, and I think, I'm not sure how many of our attendees are lawyers, but as a mediator and a lawyer, William's right, we so have to bite our tongue sometimes because we're not there as mediators to give advice. And I think sometimes the lawyer in us, when we're confronted with questions by the parties, or we're asking questions of the parties, William's so spot on. We have to think about the reason why questions are required, because we're trying to facilitate the parties to negotiate an arrangement that's going to work for them and their family. And it's not for us to be that inquisitive mind that we would normally be with a client. So the big distinction being that these are parties and that they're not our clients. And so I think it's harder for a new mediator coming to this area of work to make that distinction, and it's something that doesn't come necessarily easy. So you have to really work on the fact that these are not clients, these are parties, and that you're responsible for assisting them to facilitate an arrangement that will work for them and their family. So I think it's really important that sometimes we need to bite our tongues about what's being said. And I think one of the other things I think is a common pitfall is having stop-start mediation. Sometimes parties say, look, I can't be in the same room with my ex-wife or my ex-partner or my ex-husband. And so as a mediator, I find shuttle mediations quite interruptive and quite dysfunctional, for want of a better word, because parties aren't sensing the emotion or the genuineness or the value of seeing face to face what's being said. And so where possible, and I normally plant the seed right at the initial preliminary discussion, just to find out what the history is. And if one party says, oh look, I don't want to be in the same room, I listen to that and we have a talk about that. And then by the end of our preliminary discussion, I like to encourage or plant a seed that on the day of the mediation, because there's housekeeping things I need to talk with them about, as well as the agreement to mediate, might they trust me to come in and be together initially, and so we can just talk about the issues and put them up on the whiteboard and then just go through a procedural routine that I go through. And 9 times out of 10, when you empower people to feel confident that the mediation process is a safe place for them to be, and that it's an opportunity for them to be listened and to be heard, those parties who may express some initial reluctance at being in the same room will stay. But the option is always, look, we have a separate breakout room, we can go to another room if need be, and it's always on a case-by-case basis. But keeping parties in the same room to do the business of mediation their conflict is sometimes harder than what it sounds.
Yeah, I like that. Thank you, Debbie. And as you say, sometimes when you can encourage them to have that initial contact with each other, the worst is over, and then they can focus on the next step, which is working together. Hopefully.
And,
yes.
and I think as a mediator, they have confidence that you have a process and that procedure that you work through. Like one of my procedures is, welcoming each of them and thanking them for coming along and finding out time constraints, going through the housekeeping, where the fire exit, where the toilets are, and then working through the agreement to mediate, getting that signed, and then getting straight into it. And often if one party is somewhat reluctant to be in the same space, I might start with that party because, that party may walk at any time, and I'm conscious of that and I'm respectful of that. But if we start with ascertaining what the issues are from their perspective, and then they see that written up on the board, and then we methodically ask the other party what their issues are, and checking throughout, are you comfortable to talk about where do you want to start, and really putting the ownership of the mediation onto them. And then, you're right, Samantha, once they get over the initial, I've got to see you again, and then they realise, because these people, they come to us and they've conceived children and they've obviously got longevity of some relationship or involvement with each other, and they used to be able to agree on things. So we've just got a different hat on now they need to put on. And I kind of refer to these hats as, you once were in a close and loving relationship, or maybe not both of those things, but they were once in a relationship, and now they have to put on this parent hat on to try and respectfully work out an arrangement that's going to work for their children and themselves.
Thank you. Yes. That's so important. Thank you, Debbie. Is there anything that either of you want to add to that before we go on to our next topic?
Yeah, I wanted to say one last thing. I think another really significant pitfall, again, at all stages in the process, is bias. And I think becoming aware of one's own biases is really, really, really important to avoid the sort of pitfalls that do come from unconscious bias. And tied into that actually is that quite often at the very end, especially if you've done the mediation in one day, you see one of the parties apparently going along at the agreement writing stage, going along with something which previously they were kind of dead against. And at that point, I think personally, it's really, really important to remember, oh yeah, the aim of this exercise is not to get these people to sign an agreement. The aim of the exercise is for them to come up with something they're willing to commit to, which will really work for the children. And so having a break at that point and actually talking to each of them privately, and in particular trying to find out what's changed for the person who previously was dead against something which now apparently they're going along with. I think that's really, really important.
Yes. Sudden changes of minds do happen, but sometimes we need to dig a bit deeper. Yes, thank you. All right. So some of the do's and don'ts and pitfalls for mediation that you've discussed, I think are going to be really helpful for everybody. And we might have some time to come back to that in a bit, but I thought it would also be useful for us to look at the ethical challenges that we as mediators deal with, and how the two of you, what are the ones that are really challenging for the two of you, or that you've noticed happen, and how do you find your way around them, and what are the ones that we should be mindful of? Who'd like to start? William, would you like to lead that one?
Well, when you asked me about ethical dilemmas, my immediate response was supervision. I think to me, there's two parts to supervision which are equally important. Personally, I've got a couple of co-mediators like me, and the three of us can talk to each other and find that incredibly supportive, because you've got somebody who's like you doing the same work that you trust. So that's the kind of peer supervision. But there's also a one-on-one supervision, which for me is vitally important, because and the ethical dilemmas are indeed the thing that I usually take to my supervisor. And when you and I were talking about ethical dilemmas, Samantha, we kind of reframed it as agonizing or wondering, should I do or say something in this particular situation? So that's how kind of we defined what a dilemma was. And I just mentioned perhaps the most common one, which is at the signing stage or at the final stage, one party is doing something which you can see they don't necessarily fully agree with. So that's one. And the one that I seem to have quite often is when both of them are about to agree to something which I don't think is in the child's best interests. And for example, if they're both quite comfortable with a 10-year-old being at home alone after school for an hour. And so in that situation, Samantha's quote was "ask, don't tell," which personally I have to say to myself all the time, like a mantra, ask, don't tell. So then in that situation, just start asking questions about that situation. So hopefully they come up with an alternative plan that doesn't leave the child unsupervised.
So sort of through the questioning process, highlight the potential challenges that those sorts of decisions could have for the child.
So that's so beautifully put, Samantha, rather than saying, no, you can't do that, it's against the law.
No, that's really good, because often, sometimes I think the thing about ethical dilemmas is the dilemma stage, not the ethical stage, isn't it? Because if it's a yes or no, it's easy. It's like, no way, you're not doing that. But it's when your spider senses start going, oh, something that this is raising some alarms for me, but I'm not quite sure why, or that's when it's really necessary. And I like the fact, William, that you spoke about supervision and how important it is to talk through those things with your supervisor, and I suppose build your capacity around those sorts of dilemmas and thinking through what you do. Yeah, thank you. Yeah. What about for you, Debbie?
It's a very subjective issue, an ethical dilemma for a mediator, because it's not always clear cut, because mediators maintain different perspectives as we have different outlooks on life as well. But
yes,
one of the issues that I really tuned into are power imbalances within a mediation. It doesn't take long to identify where there might be some sort of difference of power imbalance within the parties' relationship. So, and sometimes power imbalances might occur. So, if there was an intellectual disability, or it could involve somebody being uninformed or misinformed. And so, some of those powers at play, you can just see them. And the longer you're in the mediation, you can be really tuned in. And I think as a mediator, from an ethical perspective, we have to not ignore those power imbalances, because if you've got a situation where one party's remaining very quiet and subdued and not really participating, and the other party's doing a lot of the talking, those are the kind of situations where it makes me as a mediator want to work harder for both of them to make sure that each of them are having an equal contribution in the process. So that may mean breaking into a separate meeting with either party at any time. And sometimes it can also, just one of the things that I always say at the start of the mediation is that we need to respect each other. And part of the process today, it's so important that we listen and give each other the opportunity to talk. And I will not let both of you talk over each other or talk at the same time. So having sort of rules around behaviour that's expected at the mediation is really important, because if you're that party, I can imagine, where you're feeling not on an equal footing as the other party, or if there were historic issues of domestic violence or any other issues that have gone on, the parties know everything about each other, but as mediators, we come to the mediation and we don't know all this stuff. We don't know all this stuff unless we're given some insight at the preliminary discussion stage. And sometimes parties have got to feel confident in you as a mediator, and that takes time. And sometimes that confidence if it hasn't, developed completely at the preliminary discussion stage, the mediation process is also an opportunity for the parties to invest confidence in the mediator's skill and confidence, and also to commit to the process that way. So if they're in a power imbalance situation, then it's up to us as a mediator, and I don't see it as an ethical dilemma. I see that as an opportunity to try and have equality within the process itself. It can be really obvious when you've got a power imbalance, and you probably notice that too, William, do you?
Yeah, power imbalances are definitely offer opportunities for us. So Samantha and I were talking about something that I'm sure most of us have experienced, and that is one party who at the preliminary stages comes across as absolutely fine, but then gradually you start to realise that this party has been subjected to considerable levels of psychological abuse, which have had the effect of subtly disempowering them, sometimes without them even noticing themselves that this has happened. And I just had one of those the other day, and I was telling Samantha that I decided to inquire about ways they could increase their capacity by going off to Shine or Women's Refuge or whatever before we had the joint meeting. I mean, this particular party was kind of psyched up and ready to come to the joint session because she wasn't even aware of what had been done to her.
Yeah, and I suppose building, from that, William and Debbie, as the longer we practice, the more, I suppose, the more these events happen and the more experience we get with them. But I think for me, it's always been that mindfulness that you spoke about as well, William. We get a sense of when something's not right. And for ourselves as mediators, it's so important to grow our capacity and our confidence to rely on those instincts. I don't know if that's something that you've encountered as well. What about you, Debbie?
Yes, and I think as we become more experienced and confident in what we do, the style of the way we mediate possibly changes as the years go on, because I think that's a natural process in any occupation we do as we become more confident, and I think you become very tuned into identifying behaviours very quickly when you meet as many people as what mediators do meet.
Yeah.
Yeah. I think one of the other ethical issues as well is just being aware of our own biases, because as people we have our own biases, and that might take the form of, say for instance, if somebody disclosed that they have a criminal conviction for something during the mediation, and it can be anything at all, but it's just to keep ourselves absolutely tuned into the task at hand, and don't get sidetracked by anything that you learn yourself as a mediator along the journey, because it is a journey on the day of the mediation. We start with the parties in conflict. We're providing an opportunity for them to vent and to share, what's going well and what's not going so well. And as we positively provide empowerment to the parties to share with one another, we're also providing them a forum to reach a meeting of the minds with the conflict that's brought them to us today. So it's having confidence of the process and just not letting our own biases get in our way, because we're only human.
Yes, and I think that's very true, and creating space for, like, as an aside, as myself as a mediator, when I first started mediating, I never took time off during mediations. I was always on, I was busy. And one of the things that I've learned in my practice is the importance of actually having some reflection time during the mediation for myself. because that allows me to I suppose, think through some of these ethical problems as they come up and to be more mindful of them. So I agree with you. Yes, your practice does change. Okay. So the last question I had for the two of you was around, and I know that that you're both very competent and successful mediators in terms of encouraging your parties to come to good outcomes. But one of the things that's always hard is when parties can't reach a full agreement or any agreement, and they just seem to be quite stuck in where they are. And despite what you've done with them or how you've worked with them, they're just not ready to make those commitments yet. So what advice would you have for us in those situations? How can we make sure that our parties leave the process, I suppose, with something to think of what's going to come next? How can we help them when there isn't an agreement? Any ideas?
I think if you reach the point in the mediation where matters aren't going to be resolved, I always ask the parties, okay, well, if you're now looking at an alternative dispute resolution process, which more than likely will mean the court involvement and legal intervention, what are you going to do tomorrow? What are you going to do next week and the week after that in the meantime? So what's going to happen with your children between now and then? Because if you're going to lawyer up and you're going to go down another dispute resolution process, what's going to become of arrangements that are happening now, or and what are they going to look like? And that normally gets them scratching their heads and saying, well, we'll just carry on as we are. And 9 times out of 10, often the parties will want to have some sort of band-aid measure in place, because it's in both of their best interests, and more importantly, their children's best interests, to address, okay, well, what is going to happen until we get down to that process where a judge is going to be dealing with our case? Because I always give parties, it's an opportunity to give a reality check as well, that lawyering up and going through the court process, it's not only takes a long time, it's costly, it's stressful, and if they're going to rely on a judge to make a decision, then so be it. It's their family, it's their conflict, it's their children, and often they come back to the negotiating table in their mindset psychologically, and then they start new again, trying to piece together some sort of agreement for the interim. And sometimes that interim actually then does morph into something more concrete for them. So pulling them into what's going to happen in the interim is always a good reflecting opportunity for them to think about, okay, well, what is going to happen tomorrow? These are your children. We need to sort this, in some way. Yes.
Yeah, that's really good. Thank you, Debbie. And William?
Yeah, well, that situation, in terms of the way we were all taught mediation practice, you could say that if they're not agreeing, if they're completely stuck, then what's happened is each one of them has become locked into a position. We're all taught different ways of getting people moving who are stuck in a position. And like Debbie, the most common one I use is just to start in the immediate future. Is basically just to accept it. Okay, so that's fine. You're both pretty firm in your current position. So what does that mean for what's going to happen this afternoon? Who's going to pick up so-and-so after school? Oh yeah, and what about this weekend? And so that's the easiest way to get them to move from the position, is just essentially distraction. I mean, that's the most common, simplest technique for getting somebody off a stuck position, is distraction. So we could have a break, we could just change the subject, or we could just lead them off in a more positive direction.
Yes, I like that, because sometimes it's, and I liked what you said, Debbie, is that can also be quite a good reality check for them, in the sense that, of course, they can go to the family court, or they can, they can use different options, but but they still need a plan for right now, or their children, more importantly, need a plan for right now. And that's great. I like the idea of the distraction element. I'm going to
distraction. There's so many different ways, and one of my favorite ones is just time. At that moment when they're stuck, it's just fast forward them to 10 years, or if you've got an 11-year-old, you just have to fast forward them 5 years. So let's just fast forward 5 years. Your kid suddenly is 16. That means no court can tell him or her where to live. She's going to vote with her own feet. What do you hope that might look like? And just, or, you know, to when they get married or when they're graduating, you know, fast forward and really take them to some point in the future. That can also be a good way of breaking them out of some position.
And just on that note, I also recall David and Bill in the last webinar, you know, framing it from the children's perspective to say, well, what would your children expect? What would your children expect from you for now? What would they want to see happen? And rezoning it like that. Another way is also saying, well, might we look at the review dispute resolution clause in the mediation agreement? Might you consider trialling some of this conflict that you can't get past for now, even on a 3-week basis or a 4-week basis, and just dabble your toe and see what that looks like, see what it feels like, see how the children adjust, and whether or not there is some wiggle room there to think outside what your view is right here, right now, and just try and encourage the parties to think outside where they are right now for the children's sake.
Yeah. That's really useful advice. And I suppose when we're doing that, when we're working towards that with parties so that they have something when they leave mediation, something that that's useful for them and their family, and most importantly, the children, is that while you were talking, I was thinking, well, that's a great way for mediators not to get stuck as well. Focus on that next step. If we're focusing on the what ifs and what nows and what can we do now, we're not stuck where the parties are. And hopefully our energy will lead them forward. That's always the hope. But I like that. Yes, just keeping our thinking open. It's really good. Thank you. We've got 12 minutes left. And I know that there's some questions. Some of you might have questions for William and Debbie, and I think this might be a good chance for us to do that. There's the chat feature at the bottom of the screen, but alternatively, we can see let's try that first and see if anybody's got any questions. I'll ask Samantha Brennan, who's assisting today, if there are any questions at the bottom. I think we may have had. Does anybody have any questions? I have questions. I can ask some questions as well from Debbie and William.
I just saw Martha put her hand up.
Yeah, Martha. I'll just see if I can unmute you. There we go.
Just regarding ethical decisions, sometimes the decision you make isn't ethical. There is no ethical outcome if you're working in the interests of the parties. Like I had one where there was extreme bullying from one party, but I knew, and I did all the tricks to close them down, and they'd say yes, and then carry on with the bullying again next. But this was her only chance to be heard without someone else telling her how she's going to have to share her children. And so I let the bullying go on, and that felt totally unethical, but it felt like the right decision, you know. So I don't know, there's this fine line around ethics that you have to sort of, isn't always feeling that good. Has anyone got any comments on that?
Martha, I've had situations like that before, and when I've got one party who's really outspoken and it's really blatantly obvious that they've got a bullying nature, for want of a better word, I might say, look, we're going to have a wee break, and I'm going to catch up with each of you, and I'll take each of them, and I'll take that person who's being quite controlling, and I'll say to him, how do you feel the mediation is going? And then I'll get feedback, and I'll say, did you realise that when you're talking the way you are, the perception may be, and trying to give them a reality check in terms of, if you just allow the other person to speak and even without a separate meeting in the mediation, if one person's ruling the roost, then I'll say, look, I'll just stop you there. I'd like to hear what you've got to say, and just be really even-handed and to be seen to be even-handed in the room together. But sometimes when somebody is in that situation, the person who's being bullied, sometimes they need to vent, and so that's why I might just wait for a brief separate meeting so that that person can give me feedback of how they're feeling, what progress we're making, and try and deal with it like that. But it's not easy, those situations. But we don't allow the mediation to continue all day like that, because we're not going to reach an agreement that's actually genuine meeting of the minds if one person feels like they're not being listened or heard to. And it's not something that I would actually feel comfortable with signing, them signing an agreement if it was under duress or any kind of influence like that. So it's a plain line.
Yeah, and I did all that. I did, and would ordinarily have broken them into separate rooms, but I just knew he would have walked, and again, it was through chance lost, and so so those ethical boundaries are sort of unclear sometimes, aren't they?
Hey, Debbie, do you think there's a way of almost kind of like blaming the process in a way of mediation? It's a little bit what I do in business analysis, is to say, well, even in a private session, to say this communication style is actually detracting from the process of mediation in a way, and finding a way of tactfully doing that.
I think there's a lot of truth in that, and I keep going back, and I sound like a stuck record, but in that preliminary discussion, I really have hope that each of them will have an opportunity to talk and listen and to be heard. And I often we think we're actively listening, but there's a difference between active and passive listening. So I'll actually, go back to Mediation 101 and start talking about some of the attributes that's going to make the mediation a success, as opposed to just coming along to a meeting and doing what they always do every other day of the week. So I kind of want to educate the parties to what to expect in terms of that they won't be able to talk over each other, and they'll need to listen, and they'll need to give an opportunity to share. And we've got to control that as the mediator, to allow that equality and that fairness in the process itself.
Thank you, Debbie. We've got some questions on the side. One of the questions is, how often do parties want their agreements converted to consent orders? And do you assist them with the documentation, or do you leave it to them? That's an interesting question for both of you.
I don't have very many occasions where parties do want to transpose their mediation agreement into a court order, but if they do and they both agree, then what they can do is they don't necessarily need to obtain a lawyer to do this. From what I understand, they can go to the court and they can file and prepare a joint memorandum of consent, and then they can attach their mediation agreement. And if there's any further paperwork required, the court registrar can advise them. But often, sometimes too, a court, if they go and see a lawyer, then a draft court order would be prepared and filed with the joint memorandum of consent, or a joint memorandum of the parties, and then the order can be made. So once the court order is made, then that's valid for 2 years, unless either party was to seek leave, or that's another term for permission from the court to have it revisited for whatever reason. So say, for instance, if one party was not adhering or honouring the terms of the mediation agreement, which they then got turned into a formal sealed court order, then that would enable the other party to make an application to the court to have that agreement enforced. But in my experience, I don't know about you William, but because parties, they're conscious that the mediation agreement needs to reflect what's working, what needs to work for the children now, and they need some degree of fluidity. Getting boxed into a court order isn't always attractive for families. But it needs to be able to change as the children's needs change and their needs change.
Yeah, personally, I'm the same. Not very many people at the end of the process want to turn it into a consent or go and get a memorandum or consent order. It does happen occasionally, and then I give them similar information to what Debbie's just said, that you don't have to have a lawyer to do that. I guess the reason why for us that doesn't happen very much is that we're, as I'm sure you guys are too, focused on them coming to an agreement which they're both willing to commit to, because they've come to believe that this is the fairest or the best possible arrangement they can come up with for now, and because part of the agreement that they've prepared includes a process for resolving future disputes. When you combine those two things, you know, an actual commitment combined with a process for resolving future disputes, then there's, for most people, there's less need to actually have it formalized. Not, of course, there are situations where having it formalized is very much in their interest, but not all that often.
Yeah. I think, sorry, Debbie.
Sorry, Samantha. And the flip side of that too, William, you can't take a horse and make it drink. So whether or not they've gone through the mediation process or they've just filed an urgent ex parte application in the family court, and then for whatever reason one parent doesn't want to exercise that time, or the dynamics have changed because there's a new partner on the scene or whatever, and they don't want to have that involvement with the children any longer. At the end of the day, you know, the court will be very reluctant to enforce a court order in a situation where one parent wants to relocate away, so they go to the other end of the country, and they're not bothered about seeing the children to the same degree as what they previously were. And there's always that situation. So, you know, it's a case-by-case situation.
It is, and I think one of the great things about FDR is that families can access FLAS, and so they can find out a lot of this information from, you know, what happens after mediation from the FLAS process, and so that, you know, as mediators, while I agree with both of you, obviously, that it's important to understand what the parties want to happen next, FLAS can be a great way for them to get all those questions answered and manage that part of the process for themselves, if they do decide that they want to approach the family court for a consent order.
Samantha, just before we move off the legal side of things, because we've sort of run out of time on talking about the case statutes, the law, the two documents that I would refer mediators to, and I know you'll all be aware of this, but our own agreement to mediate, you know, within there we have indemnity and exclusion of liability and release clauses. So one of the clauses in the FairWay document says neither the mediator nor FairWay shall be held liable in negligence or otherwise for any act or omission arising from or out of or during our mediation. So that's always some protection for mediators as well in terms of the legal process. And also we've got, as a member of AMINS myself, and I know a lot of you will be, we also have rules and bylaws provided for under the our AMINS registration, and also a code of ethics to refer to. So there's 13 ethical statements there. So that's always a good go-to. Those are good go-to documents to assist in dealing with any ethical dilemmas that may or may not come up. So I'll just throw that in there, Sam.
Thank you. Thanks, Debbie. Yes, there's a lot of, I suppose, there's so much more that we could have spoken about today as well. When I met with William and Debbie before today, I was thinking, oh gosh, we really need 2 hours or more time to hear all the things that you've said. But it's been really great talking with you and learning, and for, you know, for even mediators who've been in the game for a long time, the value of hearing a different perspective and the value of somebody raising things which you might not necessarily think about all the time, and which become questions for yourself as a practitioner, is so valuable. And I know that I've learned a lot from this session, and I really, what resonates with me all the time from speaking with both of you is that, that mindfulness and thoughtfulness around the parties right from the beginning of the process. And it's that relationship that you develop, that trust that you develop with them, and the journey that you go on with them, that allows or creates the opportunity for them to create commitments at the end of the process. That's so important. And so while we know the value of drafting the agreement, we have to have the content, and that's what the parties bring, isn't it? They bring that very specific content that's relevant to them and their children, and we're part of that process. So I want to thank both of you so much for your time again. It's been really, really insightful. Would either of you like to say anything before we end?
Well, yes, I did think while you were talking that increase in capacity in the parties, and I was thinking in particular, Martha, of what you'd said, that where we find out usually in the preliminary stages that there is this big power imbalance one way or another, then nowadays I guess I put much more effort into thinking about ways of party increasing their capacity before we all sit down together. And that ties in with what you were just saying. I mean, we're doing this work because we really care about people, and in particular we really care about the children. So any way that we can think of to increase capacity is always worth exploring.
And I think one of the things around capacity that's so important, or around that sort of thinking that I've become more and more part of my practice is what else needs to be on the team to help these parents. So, while legal advice plays a key role, our PFM providers do wonderful jobs in supporting our parties and helping them out of that process. We working with them. Sometimes they have support people and new partners. And so all of that creates the right climate for great agreements. And it's wonderful. It's wonderful that we have all those resources as well. And the parties do, more importantly, to get them where they need to go. And for you, Debbie?
Yes, I just want to end with saying, this year's been a year like no other. And I think as we come out this side of COVID, mediators, keep up the good work, everybody. Everybody's had a really torrid time and families are hurting. And I think there's probably more difficult journeys ahead. But as mediators, just stay strong, stay focused. And I think it's really good to network with fellow mediators as well, and to and we're part of the same family and the same team, but never lose sight of the privilege that it is to be in our position, because we provide such an important service to families and make such a big difference. So I just really thank you for the opportunity, and take care and have a lovely end of the year and holiday, everyone.
Thank you, Debbie. That's important to remember. Yes, and apologies to those of you who've written additional comments or questions that we weren't able to get to them. But again, thank you everybody for joining us today, and it's been great seeing some of your faces and having you part of our second webinar. The third webinar is going to be planned for the second half of January next year, and we'll be really looking forward to that one as well. And hope that you'll all be keen to join us. There'll also be, there is a recording of the session, and the links to that recording will be sent out to you all in the next few days. So again, thank you, William. Thank you, Debbie. I hope you all enjoyed the day, and thank you for all of you for coming along. It's been really great.
Thank you.
Thank you. Bye-bye.
Bye.